In 1998, Janet Reno asked a group of scientists and educators, prosecutors, defense attorneys, law enforcement officials, and a couple judges to come together to form the National Commission on the Future of DNA Evidence. And at the time, I had the privilege of serving on the commission and also chairing the post-conviction issues working group of the commission. We eventually put together a document on post-conviction DNA testing that helped lay the groundwork for handling post-conviction requests for DNA testing. And this was the document that we put together. This is accessible on dna.gov. Before we hear from our speakers, I just want to exercise a little bit of judicial license here and recognize the members of the commission who are here today because they all continue to contribute to this effort. On the commission, Woody Clark, who's sitting right up here. Woody, you want to stand? Who was at the time a prosecutor in San Diego, California, and now he's a judge in San Diego, California. He's gone to the dark side, Woody. Jeff Thoma, who was over here. He's in the back there, who at the time was a public defender in Mendocino County, California, and now he's in Solano County, California, also as a public defender. Norm Gahn, who's way, way, way there in the back, who was a prosecutor in Milwaukee County, Wisconsin. Now he's a senior deputy, still in Milwaukee. And is Barry in here? Barry Scheck, I think, is working, oh, there he is, over there. Barry was on the commission, and he also served with me on the post-conviction working group. And a little story about Barry. Shirley Abramson, who was the Chief Justice of the Wisconsin Supreme Court, was the head of the commission. When she approached me and asked if I would chair the post-conviction issues group, she said, the main challenge you're going to have is making sure that Barry doesn't dominate the conversation, because Barry is so passionate about this. And Barry had done, principal work with Peter Neufeld in this area. And I got to tell you, Barry was wonderful to work with on our group, and we got a lot done. In addition, there's some people here who were not on the commission, but were on other working groups, and I just want to recognize them. Cecilia Kraus, one of the real champions of scientists from the Palm Beach Crime Lab. Chris Plourd, who was a defense attorney in San Diego, California. And is Rock here? Rock Harmon? Who was at the time a prosecutor in Alameda County, California, and now is kind of retired like me, but semi-retired. I also want to express all of our thanks to Robin Jones, who really was just wonderful in managing all of us, keeping us all on task, and doing the heavy lifting for the group. And is Robin in the room right now? Oh, okay, Robin. You got to stand up. And I know she and Chuck Hoyrick and the other people from NIJ have been really responsible for putting this together. Well, we just heard the compelling story of Jennifer Thompson Canini and Ronald Cotton, and it really puts a face on the post-conviction DNA testing. And now we're going to provide the landscape of what's been done in legislation around the country, and also talking about the process of getting DNA post-conviction legislation passed. And I want to introduce Gabe Oberfield of the Innocence Project in New York. Gabe is kind of unique in that he not only has a background in the law, but also in investigative journalism. And he has worked in policy reform for the Innocence Project for the last 3+ years. And Matt Riedel, who is a prosecuting attorney in Sheridan County, Wyoming, has been the elected prosecutor for the last 21+ years, and was a deputy prosecutor for 6 years in what he would call God's country in Sheridan County, Wyoming. And Matt's going to talk to us about the process of enacting post-conviction legislation, as well as the hurdles that have been faced in typical legislation, the legislative efforts. And their statute was just passed last year. So, Gabe.
Well, thank you, and it's a pleasure to be here, and I look forward to meeting those of you I don't know, and it's great to see so many faces of those I do. As the judge mentioned, I'm Gabe Oberfield. I'm here from the Innocence Project in New York, and I'm going to tell you a bit about post-conviction DNA testing statutes. There are 44 of them in the country, and there are particular contours to those statutes that I wanted to highlight during this presentation. But before getting there, I just wanted to give you a little bit of background on the statutes generally and how we got to a place where we have 44. And first, just for those of you who don't know, the Innocence Project is a national litigation and public policy organization dedicated to exonerating individuals via the use of post-conviction DNA testing and applying the lessons learned from the 227 exonerations that now have occurred. Among those lessons is a recognition that statutory access to post-conviction DNA testing is incredibly important. And again, that's what I'm here to talk with you about today. So why is it so important? One of the important considerations is its enduring probative value. And the important additional aspect to consider about that is the value as technology improves becomes all the clearer. We've seen changes in the last 5 years, the last 2 years. DNA continues to evolve and continues to be able to shed light in ways that other forms of evidence could not. And the certainty and finality that DNA provides is unique and, again, really gives us a sense of clarity that we lacked before DNA became a part of our criminal justice system. All kinds of people are harmed when individuals guilty of crime elude justice and those who actually were convicted of crimes are incarcerated if they did not commit those crimes. Of course, that's an incredible hardship, but without using DNA to be able to go back and look at the potential for a past wrong and trying to shed light on it to bring truth, there are scores of individuals who are all affected by what isn't tested and otherwise examined. And we've seen across the country, and I'll tell you a little bit more, the statutory access has not been something that has overwhelmed criminal justice systems. In fact, quite the opposite. And the reliability of the mechanism is something that a statute provides. It gives a clear set of parameters as to how to go about this testing. So again, just a little bit more background. The first statute on the books was New York's in '94. Illinois followed in '98. And now there are 44, the most recent among them, South Carolina and Wyoming's, which we'll hear a little bit about in a moment. Now, again, as I mentioned, I want to tell you a bit about some of the specific provisions that comprise these statutes. Some are present in some of these statutes, others are not, but I want to highlight those that we at the Innocence Project consider crucially important and give you a little sense as to why. Categories of petitioners is something to think about. Making sure that it's not limited to just those who are incarcerated. There are all kinds of people who are affected by a conviction. And while those incarcerated, of course, comprise a significant portion, also those who are civilly committed, on parole, probation, sex offender registrations, and even those who have finished serving their sentences may well benefit from having the right to file such petitions. The collateral consequences, for instance, are tremendously dramatic, including issues such as sex offender registries, which can incredibly hamper an individual's ability to move on and really begin a life outside of the walls of prison for a crime he or she did not commit. Guilty pleas, confessions and admissions, another category. The Innocence Project feels that those who are, who have cases rather that have involved confessions, admissions, or guilty pleas should have the same kind of access to post-conviction procedures as those in cases that don't involve it. Now, this is not just fanciful. In fact, although counterintuitive, there are scores of reasons why individuals confess, admit, or plead guilty to crimes they did not commit. And in fact, about 20% of those 227 cases involve such circumstances. And so, we humbly ask all of you to open your minds to the possibility that, despite the fact that there are pleas, confessions, and admissions in the cases, they also can deserve, and can, and in fact, do deserve fuller scrutiny in many cases. Time limitations, and sunset provisions is another area that I wanted to discuss with you. There are some statutes that actually place a specific clock on when one files, and whether it's months or year, etc. But it can be extraordinarily difficult sometimes to get petitions filed under time limitations, and by having such limitations, it prevents the ability to go back and look more fully at the real credible claims of innocence that may be present. And very few statutes, in fact, do have such limitations. There are still a few rather that linger. And of course, as I was mentioning, DNA's power never expires, and so these statutes should not also have such limitations on when one can file. The same goes for sunset provisions, because some statutes are structured to have a set number of years after which they go off the books. We think those are mistakes as well for the similar kinds of reasons. Now, preservation of evidence. A number of states have preservation of evidence language embedded within their post-conviction DNA statutes, but it's the only place in those codes where there is a mandate to preserve biological evidence. And the problem with this is that there's this unintended window between the time when an individual is convicted and when that person files a petition. Evidence can be destroyed between conviction and petition, and if evidence is only required to be preserved after the petition is filed. And of course, if there is no evidence, petitions cannot proceed, and that is the biggest tragedy of all. Evidence inventory is a related issue. Evidence is often scattered across the criminal justice system, whether in hospitals, courtrooms, storage facilities, et cetera. And without that evidence, again, there's no way to go forward and proceed on petitions. And so a number of states have considered this issue and have thought about whether, and rather, there are a number of provisions that allow for an inventory of evidence, a judicially ordered inventory, essentially to say, let's find what's out there, let's pull it together, and let's have a sense of it, because to ask the petitioner to do that work can often be extraordinarily onerous. Victim notification. There was a question as we were closing the last panel concerning what kind of knowledge a victim may or may not want to have in the context of post-conviction DNA testing petitions, and something the Innocence Project takes very seriously. The filing of a petition, of course, we acknowledge can bring up all kinds of painful issues for the victim of a crime. And we think strongly that testing statutes should include mechanisms for victim notification and reactivation of victim services should the victim want to be able to have such available. And that's a provision that we now have in our model statute and that we offer to all of you. We're also working on a Innocence Network statement concerning victim issues and concerns. It's something that the entire Innocence Network, the 40-some-odd projects around the country, many of whom are represented in this room and a few abroad as well, and it will also touch upon these matters. Testing against crime scene evidence, testing of crime scene evidence, against existing databases. If a DNA profile can be developed from biological evidence, whether in concert with the effort to file a petition or otherwise, provisions should allow for a comparison of that evidence to the DNA database, the federal ENDIS system, if not other databases like the state level databases. And the importance of this is that they can bring about links that we might not otherwise be aware of. If the whole point of post-conviction DNA testing is to bring truth and light to what may otherwise have been a shortcoming in terms of accurate information about a crime and its perpetration, if the evidence can show links to other crimes or to other offenders within the database, this is important information to know. Yet, a very few states actually affirmatively allow for this. Expungement of DNA profiles and destruction of DNA samples, another connected issue. If a petitioner is exonerated, the samples and the profiles should not remain in state possession because the notion being that the predicate reasons for the obtaining of the sample and profile no longer exist. So, and this is something that exonerees have had issues with, certainly, and that we speak about in our model as well. Appointment of counsel. A number of states consider appointment for indigent petitioners. As I mentioned in previous portions of this conversation, it can be very difficult to file a petition, particularly for someone who's filing pro se or otherwise without specific legal training. And we're dealing with some of the biggest issues that one can contend with, literally the life and liberty of the petitioner. Of course, we don't want to speak about about counsel in every single circumstance without considering, of course, that there are important considerations that may well be worthy. When we're talking about what the threshold measure is to appoint that counsel, it's important for if a judge believes it necessary to assign, and this is actually a provision from our model that you see here on the slide. It's important for there to be a right for a judge to consult with an Innocence Project or another legal clinic. To the extent there are issues with that appointment, we want to make sure that the importance of the appointment is understood, but also buttressed with the realities that with some additional screening by Innocence Projects that can help make sure that only the most meritorious claims go forward. But again, this is just a suggestion from our model, and states handle this in a variety of ways. Delineation of response times is another area that is important. We've seen in a number of cases that have been filed via or otherwise pursued via post-conviction petitions that there's sometimes delays. And they're unintentional typically, but they lead to a lag in the ability to really clearly understand the facts at issue. And if the whole idea of a petition is to test evidence to find out about the truth that evidence can reveal, delays in prosecutorial responses, delays in judicial responses can slow the process of coming to that truth. And standards of proof. One other consideration to throw out to all of you, both for permitting testing requests to go forward and assessing the meaning of a testing result. According to our model, we think it should be when there is a reasonable probability that the petitioner would not have been convicted or would have received a lesser sentence if favorable results have been obtained through DNA testing at the time of the original prosecution. There's a variety of ways in which states handle this, but we think that this is the fairest. It's not the job of the petitioner to solve the crime for which he or she might have been wrongfully convicted. The question instead is whether the original trial verdict would stand in light of the new evidence. So I'm going to close here, but I, of course, encourage all of you to look to our website if you'd like to find out more information about the Innocence Project generally, and if you'd like to contact me directly, I'll leave that contact information for all of you. And I thank you all very much.
And Matt's going to talk now about the process of enacting legislation, and after he gets done, I'm probably going to direct some questions to them and maybe also to some people in the audience as well if there's time. Matt? Oh, if you do, when you come up, if you have any questions, please come to the microphones because they're taping here and they need to be able to hear you.
Good morning. On March 13th of 2008, Wyoming became the 43rd state to enact post-conviction DNA testing legislation. Obviously, we were Johnny-come-latelys to the issue, but we've been asked to come here today and to talk about our experience in the legislative process, some of the lessons we learned, the mistakes we made along the way, and the work that we have left to do in our state. I want to give you a little context for the legislative environment in the state, particularly as it pertains to post-conviction testing. Unlike the experience in a lot of states, there was a decided lack of urgency felt in the state of Wyoming surrounding the issue of post-conviction DNA testing. In large part, I think because Wyoming has not to date experienced an exoneration, most prosecutors in the state have never been contacted about a case suspected of representing a wrongful conviction, and the few that have never received a request for access to the evidence for testing. Our legislature at the same time is what we call a citizen or part-time legislature. During a 2-year biennium, our legislature meets for a total of 60 days. If it's a general session, for 40 days. If it's a budgetary session, for 20 days. The 2008 session, which produced our legislation, was a budgetary session, that is a 20-day session. In addition to the reduced number of days that the bill can receive attention, the rules require that if you're going to introduce non-budgetary items during a budgetary session, you must receive a 2/3 vote before it can be considered in either house. In the run-up to the 2007 legislative session, the session before the legislation was actually passed, the Rocky Mountain Innocence Center in Salt Lake City, through one of their board members, University of Wyoming law professor Diane Corsell, reached out to members of the Wyoming legislature hoping to enact post-conviction DNA testing legislation in that 2007 general session. Professor Corsell and the Innocence Center received advice that there was too little time to draft legislation for that session, to create the necessary interest, to obtain sponsors and the support that would be necessary to bring that about. And so instead, Katie Monroe, the director of the Rocky Mountain Innocence Center, and Professor Corsell provided legislators with information regarding the issue of the DNA exonerations around the country, the need for an enforceable right to post-conviction testing and relief, and the type of relief that would be appropriate if the results indicated a wrongful conviction. And by the end of the 2007 session, one legislator had developed a passion for the issue and was able to convince the Joint Interim Judiciary Committee to accept post-conviction DNA testing as a topic for interim study. In our state, what that means, that determination is significant because only a handful of topics are actually taken up by the joint interim committees when the legislature is not in session. What that told us as prosecutors is that it was likely that some type of bill was going to be passed, if not in the 2008 session, then certainly by the 2009 session. Committee bills receive significant support within the body of the legislature because they've been studied over the course of the preceding year The language has been vetted during committee meetings, and it's ordinarily presumed that the bill will enjoy significant support among the members in both houses represented on that committee. And if a committee bill is not ready to go forward, the practice is that it is not placed on general file in either house until it is ready. In June of 2007, the state public defender, Professor Corsell, and myself testified before the joint committee. I appeared on behalf of our State Prosecutors Association, and our testimony was largely informational and what the issues might be in enacting such legislation. As prosecutors, we were not concerned about the possibility that such a bill would pass. Our concern was that we expected a bill would pass. What we wanted was a good bill. We wanted a good piece of legislation. In August, Professor Corsell, myself, and Katie Monroe were invited to testify before the committee, and Katie and I had the opportunity to talk both to the committee, but to each other. And during the course of our conversation, we found a number of things that we were able to agree upon. And during a break in the testimony, Katie and I discussed the issues, and I don't think either one of us was sure that we would be able to come to an agreement on the different issues that we anticipated would come up and that we may have disagreement about. But I think we both kind of took a leap of faith in some respects, and we came back to the committee with a suggestion, and that was that we would form a drafting committee representing the different stakeholders involved, primarily prosecution, the innocence community, public defender's office, and we wanted to include our attorney general's office in the actual drafting, and that we would draft proposed legislation for the committee to take a look at. The committee took us up on that particular offer, and we recognized that collaboration and consensus was going to be critical if legislation was actually going to be enacted. The Rocky Mountain Innocence Center and Professor Corsell participated representing the innocence community. There were 3 of us that were state prosecutors representing the Prosecutors Association and also acting as liaisons to the Sheriffs and Chiefs Association and to the victim advocacy community within the state. The Public Defender's Office participated, as did our Office of the Attorney General. We prepared a draft and circulated it among the group. We had some discussions about it, made some changes, and quite honestly, we fairly quickly reached consensus on what provisions ought to be included in the draft to go to the committee. The first lesson that I learned is how fragile a consensus can be. We had reached consensus with all of the participants in the drafting process, and early on we found out that there was consensus even among our group over one of the areas that we had previously agreed upon. We had a third-party sampling provision in the legislation that provided the opportunity for defense counsel or for someone representing a convicted individual seeking post-conviction relief, or for the prosecution to obtain third-party sampling for elimination, inclusion, or for the purpose of putting forward a third-party defense in a case. We had modeled ours we were sensitive to the fact that this may be an issue, and we had modeled ours on the ABA standards for DNA evidence, which provided protections for the third parties by way of notice of application and affidavit, the opportunity for a hearing before the order is entered, and right to representation of counsel. As it turned out, two of the members of our consensus were not that thrilled about that particular option. The Public Defender's Office was concerned, and I thought that this made some sense. They were concerned because we had placed a provision in there where they would provide counsel if necessary, and they were concerned regarding creations of conflict of interest within their office. We thought that there was a mechanism already in place to deal with that particular issue, but that made some sense. The Attorney General's office was concerned about the constitutionality of the issue. That one still has me somewhat baffled, but I learned as a result that's bad on me. That was my fault because I did not do an adequate job in educating our constituents within the drafting committee about that, and that was within my parameter. As a result, the first day that it was considered in the Senate, and we knew that this was a possibility and had discussed it among the group, the third-party sampling provisions were removed from the legislation. The provision or the proposal passed on third reading in the Senate on a vote of 30 to 0 and was received by the House the next day. We had already determined that this was not going to be a make or break issue for us, and from the prosecutor's standpoint, we saw this as being more beneficial to the defense and innocence community than it was to prosecution, because we believed we had other opportunities and other means of obtaining those elimination samples. It had a fairly smooth pass through the House until we got to the second reading in the House of Representatives. And in the House of Representatives, on second reading, one representative made an amendment on the floor of the House to remove a provision. And that provision, we believed, affected the overall integrity of the bill. And from the prosecution side, we believe that it was a make or break issue for us. As a result of that, we notified first the chairman of the Senate and House Judiciary Committees. We notified prosecution, law enforcement, and the victims community that we may have to pull support and try to kill the bill. And Katie and I were attempting to make contact at this time, which eventually was facilitated by the chair of the Senate Judiciary, with the representative to discuss that with Representative Brown. It passed second reading with the amendment at about 5:30 in the afternoon on one day, and the very next morning came up. They were coming up on the close of the session, and so they were trying to run through legislation fairly quickly. And so it came up at 7:30 in the morning, and we had not had a chance, or been able at least, to contact Representative Brown in the meantime. And so it passed on third reading with this difference. We were able to contact, with the aid of the chair from Senate Judiciary, we were able to contact Representative Brown, and Katie contacted him first, explained the position of the innocence community and the impact they believed it would have upon the legislation from their perspective. And I contacted Representative Brown after that and explained our position to him. We both were able to accomplish that by email, which was an incredible help, and we learned the value of email in the legislative process, because every one of the representatives and senators in the Wyoming legislature is sitting there in committee or outside of committee with their laptops in front of them. As it turned out, Representative Brown was not intending to do what he did. It was small p politics in a small town way. What had happened was there had been a case that had garnered some considerable press coverage within the state of Wyoming, in which defense counsel, trial counsel for a defendant, happened to be a member of the public defender's office and a good friend of Representative Brown. And Representative Brown felt that the state public defender's office had tried to throw his friend under the bus in post-conviction areas, and he felt that this bill encouraged that and encouraged the filing of claims of ineffective assistance of counsel when what was involved was a tactical decision made by defense counsel. We explained to him that, in fact, this provision recognized that there were tactical decisions that can be made that would not represent ineffective assistance of counsel, and Representative Brown graciously agreed to a parliamentary solution to it that resulted in the Senate version being passed. The language was restored, and on March 13th, it was signed into law by our governor. The final tallies, the final vote in the House or in the Senate was 30-0. In the House, 57 ayes, 0 nays, and 3 were excused. Some provisions of our legislation allow for any person convicted of a felony, if testing results would be material to the identity of the perpetrator or an accomplice, enhancement of a sentence or an aggravator alleged in a capital case. There has to be a showing that the evidence is still in existence and in a condition to be reliably tested, and that the evidence has the potential to produce new, non-cumulative evidence of actual innocence. Cases occurring after 1999 must demonstrate due diligence or the existence of ineffective assistance. The burden for obtaining an order for testing is merely prima facie evidence. It addresses the qualifications of the testing laboratory. It provides for a right to appointed counsel for indigent defendants. The costs of testing are paid by the petitioner unless the petitioner is incarcerated, is needy, and the results support the motion, in which case they're paid for by public funds. If the results are inconclusive or consistent with guilt, there is a denial of a motion for new trial, and the results are provided to the parole board. If the results are consistent with the theory of innocence, the matter is set for hearing on a motion for new trial. And There's a provision in there for stipulation of the parties on favorable results for a motion to dismiss the original charge by the state, which results in a vacation of the conviction consistent with the evidence, an order of actual innocence and exoneration to be ordered, and an order of expungement to likewise be ordered. There is also a right to file for relief under this statute that may not be waived. So as a condition of a plea agreement, I cannot insist that a defendant waive this right. On appeal, and it was interesting, this topic came up on the shuttle bus ride out here. On appeal, the appellate rights for an order for testing are only appeal pursuant to a writ of review, so it's discretionary with our Supreme Court. If it's on a ruling for the motion for new trial, that can be directly appealed by either party to our court. There is one filing of right except or unless there has been some kind of a Brady violation involved. And we also included a provision that provides for consensual testing. The state can consent to testing without a motion being filed, and if the results are favorable, the defendant may file for a new trial pursuant to the act. What we feel we have left to address is a compensation package in the event we should find someone who was wrongly convicted. And we also have agreed that we will see if we can work through a non-DNA based relief package. We recognize that, as the old saying goes, the proof of the pudding will be in the tasting. We've not yet had any case come to the surface yet where a motion has been filed pursuant to the statute, and it will only be when we have those concrete cases in front of our courts that we'll see if our legislation is performing in the manner in which we hope that it will. Thank you.
You know, Matt just mentioned that it's been close to a year now since the enactment of the statute, and there haven't been any petitions filed. Gabe, has there been a flood of litigation in any of the states based on the experience of the Innocence Projects around the country?
Actually, no. As I mentioned in my presentation, it has not been something that we have observed, and in fact, we have made inquiries around the country and have found that echoed. The passage of post-conviction DNA testing statutes does not prove to be onerous on states or jurisdictions. The most meritorious claims come to light, and if the idea is to find the truth behind those claims, the systems need to be in place. But they have not been, they have not so burdened systems that the systems can't handle the number of petitions, because they have been rather few.
Hey, Christine, come on up to the microphone. Chris, go up there with Christine. I got a question for you guys. I'm the token judge on another NIJ project that I do with Christine Funk from Minnesota and Chris Plurd from San Diego. It's a DNA for Defense project. And, you know, on that line regarding that there's no flood of litigation, do you guys see, you know, in Minnesota, California, I know you're working with innocence projects around the country and defense attorneys, a problem in a lack of knowledge in the defense bar? And Woody, I can ask you the same thing since you did a lot of training with prosecutors in the prosecution bar. My guess is that a lot of the people in this room who are defense attorneys and prosecutors are the ones who have been doing this work for a long time. And my impression has been that with the turnover in public defender offices and in prosecutor offices, that this is just a constant need for education. Christine?
I was actually thinking when Gabe was talking, I was sort of processing this. In the public defender's office, after you try a case and you lose it and it goes up on appeal and you lose the appeal, it's not uncommon for the lawyer to say to the defendant, well, there's nothing else we can do. And if the defendant isn't educated enough to know about the Innocence Project, I was sort of thinking about, we have in Minnesota the oldest prison newspaper in the country, and I was thinking, I wonder if the Mirror could run a story for defendants that are in prison to let them know, educate the defendants about the Innocence Project. You're right, many of our lawyers aren't educated in this. In fact, Angeline Swenton and I last night were speaking on a talk radio show, and the person who was interviewing us was asking us, now what's this Innocence Project thing? And I was really stunned by that question.
Chris, what about you in San Diego?
A lot of lawyers don't, once they're done with their case, they're done with it. And most of the cases percolate up from the defendants or the defendants' families. Lawyers aren't typically a conduit, but they're the ones that are probably most knowledgeable about the details of the case, whether there's some biological evidence available. I mean, they are always contacted, and they're usually very surprised, oh, you're looking into that. And typically they say, there was a problem with that case. I really felt like there was something that went wrong there, and this guy should have been convicted. And they're, oh, I'm glad you're looking into it. They should be the one that should be bringing these cases to the forefront, but I think they underappreciate what is in their caseloads, their closed caseloads, and so forth. So I think we need to better communicate with those lawyers in that regard.
And Woody, is the same true with prosecutors? I mean, I know APRI, Paula Wolf's here, they have a great training program, DNA, through APRI, but you can't reach everybody.
Right. I think there's been certainly change over the last 10 years or more in certainly the attitudes of prosecution agencies and so on. I agree a great deal with what Gabe said about these cases tend to percolate to the top, but at the same time, and I know our most noted exoneration in our county of Fred Day, who was one of the original 26 cases featured in the book that Dr. Morgan mentioned, Convicted by Juries, Exonerated by Science. He claimed innocence the entire time, but it took 10 years to find a lawyer who really grabbed onto it and took the steps necessary. Ultimately, that lawyer who took an interest in the case found out the evidence was about to be destroyed shortly after that. And without her taking those steps, Fred Day never would have been exonerated. So I think it's a lot of things that go on to balance and make this tool known to everyone, and then to be able to use it accordingly.
Okay, we got Barry Fisher coming in here, wanting to talk.
Ron,
Yeah,
can I
go
just add a
ahead.
point of clarification? In terms of the percolation comment I made, I just want to be clear that, yes, while meritorious claims should always come forward, that the whole point of having statutory provisions in place is to make sure that claims have a way to be heard, and so that the conversation that, or rather the comments that we just heard, alluding to 10 years of efforts to try to bring the claims to light, won't happen in the future.
As far as testing goes, one of the things over the years that I've really appreciated is getting to know some of the people in the laboratories that do the work where the rubber hits the road. Barry Fisher is going to be talking in a second from the LA Sheriff's Crime Lab. I already introduced Cecilia Krause, Stephanie Stoylov's here from Miami-Dade, and Dean Gialamas from Orange County. They really do the valuable work in this area. But go ahead, Barry.
This presentation made me think of 2 points. One is kind of a little narrow and one is a little broader. The retention of biological evidence that's required in these post-conviction statutes places a significant burden in public safety agencies across the country. We're just constantly building more and more and more deep freezes. And one thing that the federal government could do, the Department of Justice, NIJ, is to sponsor some more research into looking at storage of DNA evidence, biological evidence, in ways other than just the deep freeze. After all, you always read stories in National Geographic about doing DNA testing on Egyptian mummies and whatnot. So, but we need to have something to hang our head on so we don't run into legal decisions that seem to require us to store evidence in the freezer. On a broader basis, while this conference is focusing in exclusively or almost exclusively on DNA testing. I think that, and I've made this point often, that forensic science provides a whole constellation of tools and services that can be used in innocence-related processes, and rather than just focusing in on establishing places that innocence projects can take evidence to do DNA testing, perhaps it ought to be expanded into the whole range of forensic science testing. There's a pretty big discrepancy compared to the forensic science available to prosecution as opposed to defense. There's relatively little of that available, and this could be the start of some area that could be looked into that. So just a couple of things to think about.
Yeah, I think Robin was telling me in 2010 that NIJ is sponsoring a trace evidence, pattern evidence symposium that kind of goes along that line as well. Yeah, if you could just introduce yourself for the...
My name is Scott Ehlers. I'm with the Office of State Senator Rodney Ellis in Texas. We had a recent exoneration in Texas, a guy named Tim Cole, who was posthumously exonerated. He died in prison prior to being exonerated, and he was ultimately exonerated because the guy who did the crime admitted to it, and it came to light that he actually did it. Luckily, in his case, the evidence had been preserved, I think accidentally, that the evidence had not been destroyed after his death. I'm wondering if there are any states out there that have something on the books where maybe the family could come forward and maybe petition the court to keep evidence after somebody dies, or if there's some other way in which that evidence could be retained. Obviously, we don't want to overburden police departments in retaining this evidence forever, but I'm just wondering if there's something out there right now that allows for that.
Gabe?
In truth, I don't know of a specific state with such provisions, at least within the four corners of the post-conviction testing statutes. But Scott brings up an excellent point, with the balancing that he raised, because claims certainly can and may well be colorable even posthumously.
And Ron?
Yeah, Matt?
The point, though, that Barry brought up earlier is very real. As I recall, when you were on the commission, Ron, you had the officer involved or in charge of evidence custody for LA County SO, I believe, who testified that they were renting a reefer truck every 6 months just to try to keep up with the biological evidence that they were receiving in that agency, and that would have been like, what, 1999, 2000?
Right. Yeah, it is an issue.
My name is Josh Markey. I'm a district attorney in Oregon and sit on the board of the NDA with Matt Riedel. This question's to Mr. Overfield, but also to Matt, because I don't know if I've ever discussed this. Since the purpose of DNA testing is to bring truth and light, isn't the best way to prevent cases like Mr. Cotton's and others to have more extensive pre-conviction testing rather than simply trying to fix the mistakes afterwards? And in light of that, why is there this requirement, I know that the Innocence Project and a number of others, requiring the expungement or the eradication of DNA from those people who either potential exonerees who are exonerated or people who are not convicted?
Why don't I take the first part of that? I don't think that there's any disagreement, Josh, that the best system is one in which the wrongfully accused are exonerated pre-trial, As a matter of fact, that was one of the things that I didn't know it at the time, but since Katie Monroe has told me that when I made that point before our legislative committee at that hearing in August, that she understood that we might be able to work together. Because I would point out to you that in the post-conviction arena, that cuts in the way that I think your question is aimed at. It also implicates other things too. It means that there's an obligation on us as prosecutors, as the ministers of justice, to try to figure out better ways of handling traditional types of evidence that have been problematic in this area, and of figuring out ways that are more effective in doing our job. You know, things like we know about the problem, and we heard this morning, and we're reminded of the problems inherent in witness identification. Things of that nature, we need to figure out how we and our law enforcement officers can do our jobs better in that respect.
And just wasn't sure it was working. Just to build off of those comments, yes, the best innocence reforms are those that were alluded to in the presentations that preceded ours, thinking about ways to make eyewitness identification more reliable, issues with forensic sciences. Those are, and thinking about ways to make them all the more reliable. Those are the kinds of ways that the Innocence Project feels the issue is best approached. The conversation that we're having right now is about post-conviction DNA testing statutes. You know, we as an organization, the Innocence Project, focus on the exculpatory power of DNA. You know, we're not a defense organization. We work specifically to look at cases where new light can be shed via DNA, so there is a distinction to be drawn between those issues. And I just wanted to underscore that yes, again, the strongest innocence reforms, the ones that get you, if you will, your most bang for your buck, are the ones that we've talked about in you know, these other, whether eyewitness identification or forensics or recording of custodial interrogations. These are conversations that you know, we encourage those to be having in the context of this conference, but you know, again, with post-conviction DNA testing statutes being the focus.
Robin, do we have time for 2 more questions? Okay. Yeah, go ahead.
Malia Brank from the National Association of Criminal Defense Lawyers. It sounded from the Wyoming experience like 2 things came up in the statute that I want to ask Gabe to address the national context on. One being the idea of third-party testing, and the other cost, because I looked at the cheat sheet, and that was not sort of covered in the review of the 44 statute. So as sort of the more detailed aspects of the statute, could you address the national context on those 2 issues and sort of where the debate lies?
Would you mind just clarifying the question a little bit?
Sure.
What specifically are you?
Well, I'm wondering if you know, if you're writing a model statute, where is the sort of guidelines on third-party testing, and on the cost issue? Because I noticed in the Wyoming statute, although it sort of went by quickly, that there is a provision basically that if the DNA evidence does not come out to support the claim of innocence, the cost goes back to the defense.
Well, our model actually does address these issues. I didn't specifically raise it during the comments here, just because ultimately we could be here for 7 hours easy if we wanted to talk about all of the intricacies of these statutes. But I think the fairest answer is to say that both are handled in a variety of ways by states, and so there isn't one particular suggestion to give you. And I think the statutes as a collective are instructive on the matter. And we have language in our model as well that I would encourage you to go back and reference.
Ron, if I might,
Yeah.
to follow up on that too, with respect to the third-party testing piece of ours that was left out of the enacted statute, we made a conscious decision. We were aware of what is in the Model Act that the Innocence Project has provided. We made a conscious a decision to pursue the ABA's version of it, and the reason we did was because Wyoming is a red state, and that Republican thread through our politics is primarily fiscally conservative and libertarian in nature, and we believe that there were greater protections afforded for the third party under the ABA's version than under the Innocence Project's version, and so we went that route.
Okay. Yeah.
I'm Bill Overly from the Alaska Innocence Project, and this is for Mr. Riedel. Prior to this process, what was the opinion of the prosecution community on the necessity and possible benefit of this statute, and how has that changed, if at all, in the process?
We weren't sure if there was a necessity for it or not. We did not have, there were no strong feelings about opposing this. We felt that it was probably something that we should have in our state. We just wanted to try to make sure that the bill that we had the measures of integrity we believed were necessary so that the victims, the courts, and those who might be wrongfully accused, there would be legitimacy to the process, essentially.
And has that changed at all, any view?
No, but like I said before, the proof of the pudding is going to be in the tasting.
You get the last word.
Okay. First, let me say I completely agree with Barry Fisher that this whole discussion opens up opportunities for how do we store evidence and what should be stored. In North Carolina, my name is Chris Moom, I'm from North Carolina. In North Carolina, we've had a statute on the books since 2001 for preservation of evidence in cases. And we constantly, at the Center for Actual Innocence, get cases where evidence has been destroyed since 2001 because the statute, one, is considered an unfunded mandate for storage, and two, because there is no consequence for destruction, premature destruction. The statute requires notice of destruction to go to the defense attorney of record and to indigent defense services. And I've been tracking the notices of destruction for the last 3 years, and there's one county in North Carolina that provides notice of destruction. So what do you see in the statutes across the country that provides for consequences for premature destruction of biological evidence when there's a statutory requirement for preservation?
As far as the consequences are concerned, it's not an aspect that specifically I've tracked across the statutes. And actually, though, I would suggest, though, that that question be tabled. There's going to be a discussion later this afternoon, not specifically about statutes, I should caution, but about preservation of evidence issues generally connected to storage and the like, all of which will be very readily aired there because it really merits more than just a passing moment in the question and answer period. And so, there are different ways in which states think about preserving evidence. Some within post-conviction DNA testing statutes, other as standalone statutes, as Chris was referring to. And so I think it's better to hold off on an answer to that question until that fuller conversation.
Yeah, so maybe Chris Plurd, I think you're on that panel. You take some notes and you're going to address that maybe?